Good morning. My name is Elizabeth Bunn, and I'm the organizing director of the AFL-CIO, a position I've held for about 4 years. Prior to that, my background includes working with the Enforcement Litigation Division of the Board after law school, and 25 years, first as an attorney, then as senior staff and an officer at the UAW. I oversaw the union's organizing program in the non-manufacturing sectors there. So I have many, many years of experience in helping workers to organize. To Manisha's compelling argument, I would just add one small point. We suggest changing slightly the proposal concerning the employer's response to the scope of the bargaining unit. We recommend that an employer who objects to the worker's proposed bargaining unit set forth with specificity who they contend must be added or subtracted in order to support their contention that the unit proposed is not appropriate. We think such a proposal makes all the sense in the world. It prevents an employer from merely objecting for the sake of objecting in order to cause delay and gamesmanship, and it allows both the employer and the workers' representative the opportunity to problem solve their disagreement, hopefully satisfactorily.
Ms. Bunn, have you had specific experience with respect to the problems that you suggest exist in the current hearing process?
My own experience is that many employers, too many employers, not all, but too many employers, in fact, seek to delay the holding of the election. And they'll do that through raising unnecessary objections, challenges, frivolous legal arguments. We'll talk later on as part of other proposed rules that the goal is delay, just pure and simple. And since the purpose of the pre-election hearing is to decide whether or not there should be an election, to the extent that the board, consistent with due process, can delay litigation of issues that are unnecessary to that question whether there should be an election is appropriate. But yes, unnecessary delay has been our experience in many, many organizing campaigns.
Are there circumstances where the position of the employer being presented only at the hearing or sometime during the midst of the hearing create any kind of issues with respect to the petitioner?
Right. It is difficult, again, since the purpose of the hearing is to decide whether there's a question concerning representation. It's important for the workers and their representative to understand what the employer's position is, and to walk into a hearing without having that information is unnecessary and unhelpful.
I would add to that just that one of the consistent responses that we received from union side attorneys was how difficult it is to prepare for a hearing when you have no idea what the positions the employer will take at that hearing are.
Yeah, along those lines, if one assumes that 7 days is an adequate time for an employer's counsel to plug into a particular situation and identify the relevant issues, because of this preparation issue and also the benefits of trying to negotiate a stipulation, would you support, for example, an alternative if the board required some written statement of position at day 7? Would there be utility if the union then had another, 4 to 7 days thereafter to take that into account in its preparation for the hearing or in the negotiation of a stipulation?
I would say that that's not necessarily the case. I mean, again, the union has a fairly good idea of what it believes the issues are at the time that it files the petition, and is in a position to, in many cases, respond to those. It's the sort of the tactics of raising issues that are completely unforeseeable because they're, in often cases, tend to be frivolous arguments that blindside the union that it's not prepared to respond to, and those don't necessarily need a whole lot of time to prepare for. It's just if you had notice prior to the commencement of the hearing of those issues, then the union's in a better position to respond to those. I don't think they need 4 to 7 days necessarily to respond to those issues.
But presumably, notice of frivolous positions is as useful in advance of the hearing as notice of non-frivolous positions. I mean, is that a correct proposition?
Yeah, I would absolutely agree with that. But I wouldn't say that you necessarily need an extended period of time to prepare a defense to those or a response to those.
Okay, thank you.
Vis-a-vis the timing here, would you support looking at this on a variable scope in terms of deadlines and which being the statement of position depending on the size of the petition for a unit?
You know, I think that the crafting of these rules in many ways is extraordinarily elegant, and hats off to all of you who have put time and energy into this. And I think that the exception allowing for exceptional circumstances would cover any particularly difficult situations.
Do you think we should define exceptional or special circumstances more thoroughly?
I actually don't. It reminds me of early on when someone said, let's define just cause in a contract. And it's like, you know what, sometimes it's easier to have the general concept and work through it that way.
Okay, and one last quick thing. On the premise that it will help the parties sort through the bona fide real issues and perhaps lend toward whatever other reforms we might be thinking about, would you support actually asking the petitioning union to come up with a statement of position that more fleshes out the legal issues rather than just simply the petition itself, such as, for example, why the readily identifiable group was chosen, what the community interest factors are that support it, why certain positions were excluded?
I would say I think many of those issues are, the board has fleshed out general principles that are fairly straightforward and guide on those. And the structure, as I understand, is petition is filed, statement of position provides a response, and then the union has to provide a response to those issues raised in the statement of position, therefore joining those issues. And at that point, I mean, I think that you have a situation where both parties will be knowledgeable enough to know why positions are taken and be able to articulate their position, and that the board will be in a position to knowledgeably respond to those.
Okay. We'll have to move on. Thank you all.
Yeah, thank you very much.